Aaron Levine, LG Insurance, with another episode of And Insurance. We're here with Kevin Asadi from Zager Fuchs in Red Bank. Kevin is an attorney. He's done work for me personally, full disclosure. We've done some networking together. We've done some business together. We've kind of done it all, and we can't wait now that the limitations are lifted on the bars that we can get out and have some drinks together.
It's about time.
Finally, right? So give me a little bit about what you do, how long you've been practicing law, what your area of expertise is, and then I want to get into the topic at hand and talk about, wills, trusts, and estates with you.
All right. Thanks a lot for having me, Aaron. So I'm Kevin Asadi. You know me very well. We've known each other for a long time, haven't we? It's amazing how fast the years go by, isn't it?
It's that gray in your beard.
It is the gray in my beard. It wasn't gray when we first met. I didn't have a beard when we first met.
I didn't have a beard.
Probably couldn't grow one.
I can't shave mine off now.
So I've been an attorney since 2005, and since that time, my office has been on Broad Street in Red Bank with the law firm Zager Fuchs. And with Zager Fuchs, I do a lot of real estate work, a lot of estate planning, land development, landlord-tenant, property taxes, and more. I really consider myself a family attorney, an attorney that a local person would need several times in their life, and they can call me, and we could take care of them.
That's awesome. So I know you do a lot of land use stuff, right? You sit on zoning or planning still for some townships? Or
Yeah, this is my first year not sitting on a zoning or planning board since probably 2008.
Too busy coaching soccer.
Yeah, a lot of soccer now. I'm volunteering my time in a different way in town, but it's mostly soccer these days. But I really, really enjoy the planning and zoning board work, and professionally, I do a lot of that too.
Right. So that's great. But we're not going to talk about that. We're going to talk about wills, trusts, and estates. You and I have worked on a couple of projects together. You've reached out to me for some help, when certain individuals become deceased and their estate transfers over to their next of kin, when there's a lack of a will and things go into the court system through probate, we have to get an extra bond, and it becomes a little bit of a shock sometimes for a kin that's not financially set up for it. So I want to talk about how do we properly set ourselves up for the unknown and for the future. What does it look like? When do we do it? I'll let you start talking, and this is your field.
Yeah. When it comes to convincing a person to get a will and the other estate planning documents, sometimes that can be tough. Sometimes they've even paid for it and had the drafts all done and finalized, and they don't come in and sign it. And I can understand.
Why would someone hesitate to do? I just don't understand.
I think it's hard to contemplate your own death for a lot of people, and I think that's natural. But it is something that really should be done. Everybody knows and can name several reasons why they should have their estate plan done.
Right.
But a lot of times people think to themselves, I'm not that wealthy. I have a spouse. I have 2 kids. If I were to pass away without a will, the right thing is going to happen. We know exactly what's going to happen. But do you really? There are a lot of things that you might not know about, and I wanted to share a couple of those things today to hopefully encourage people to get wills, even if they think they really don't need them.
Right.
You touched on a big one, which is if you were to pass away without a will, then in order for an administrator to be approved to administrate your estate, that administrator would have to purchase a performance bond. That performance bond is not only contains a lot of hoops you have to jump through, a credit check, and other hoops to jump through, but it's also the premiums for that bond is very, very expensive, a lot more than most people realize.
Right. So the bond is an insurance policy. It's a vehicle. It's an insurance vehicle to protect the state should someone steal funds from the estate. Right. So it's an administrator bond. Performance bond is more construction. And it's a credit check. And if somebody, the administrator who's responsible for this estate to distribute assets or sell a house, has bad credit, cost of insurance is going to go up on it also because they become a little bit higher risk on it. So it becomes a hassle for sure when it gets down to it. And then you always have to follow up to make sure that the estate is closed in the eyes of the court and get everything signed off on, because premium is due every year on these bonds. And people are like, well, we're done. Well, did you get the court to sign off on it? Are you really done? And then, they wind up having to pay when they shouldn't have, because everything could have been settled, earlier on.
It's quite an expense, and sometimes it even becomes prohibitive for some people to be able to administer an estate. If they don't have the money or the credit to get the bond, then they may be discouraged from even going through with the process, and that might cost them a lot of money that they would have inherited.
So staying on this topic real quick, so the court in many cases, or the insurance company in many cases, requires an attorney be retained and be on file with respect to the administration of the estate. How does that work? Because you sign a letter of engagement with a client, and you have a duty then to help settle the estate. How does that whole thing tie in?
Just like any other client, the attorney for the estate represents the estate. A lot of times you may have a dispute with another beneficiary, and they would hire their own counsel and maybe engage into the matter, but the attorney representing the estate's the only client.
Got it.
And that's who all their duties are focused on that estate client.
Okay.
It's not even necessarily the administrator's personal attorney.
Okay.
It's the estate's attorney.
Estate's attorney.
Right.
Interesting. So there could be multiple, if there's a dispute, the administrator might need their own counsel.
They might need to.
So the lawyer's always making money.
It's
That's
too
what it
much.
is.
Too much of this.
So I know when we did my wills, and I think it was right around when my first child was born, right? So I had a personal concern of, should something happen to me, we have a guideline for the care, custody, and custody of my children. And that's kind of when I approached you to do this. Do you see that a lot, or is that less common nowadays?
No, it's definitely when people buy a house, when they have kids. They may have kids, and now they're about to get on a plane, and they start worrying about it. And it's a very likely time for people to start worrying about taking care of that kind of business. When you have young children, or even adult children, young adult children who's, you're not ready to see inherit all of your wealth, one thing a lot of people do is set up a children's trust. And the point of the children's trust is not only to establish the trust for what happens if the kids are still under 18, but it could also establish what happens up until they're any age that the testator decides is the appropriate age. I wasn't around in the 40s, but I get the sense that in the 40s, an 18-year-old was a much more mature person than I was when I was 18, and certainly today's 18-year-old.
You don't have to tell those stories.
But, maybe somebody a long time ago inheriting a great sum of money at 18 years old may have had different ideas as to what to do with that money, versus now an 18-year-old coming into $250,000 may not make all the correct decisions with that money. If the death occurred prior to the child being 18 years old and there's no will, then the money would be held in a state custodial account until the child turns 18 on their 18th birthday. Here's your money. That money that's handled by the state doesn't get invested in the same manner as it would if it were in a private trust. These trusts are very easy to create. They're created just through the language in the will, or they're contemplated just in the language in the will itself, so that it's actually created after the death. When the will is being executed, the trust will be created, and all that work becomes necessary.
So
If
we
it's
don't
not
need
necessary,
to
you don't have to do it.
create the trust, fund the trust, use the trust money to then purchase life insurance. Everything can kind of be done in a more simple fashion. Buy life insurance as you normally would, right, on each of the living parents. And then should a situation arise, the will sets up the trust if both parents predecease.
Absolutely. And a lot of times, most times, and hopefully we hope that these children's trusts never become necessary, and many, many times they wouldn't. So that saves you from having to establish expensive trust work. That's what's called a testator's trust, a testamentary trust, rather. That's a trust that's contemplated in the language of the will itself versus created at the time the estate plan is
So
drawn
why would
up.
anybody set up a separate trust also funded by life insurance, or that has life insurance proceeds that go into a trust? So why would you set up a regular, I don't know what the right words are for it, but why do people set up other trust accounts versus having everything in the will in this simple children's trust?
Different trusts have different purposes. A special needs trust, for example, would be created, and I'm no expert in elaborate trusts, but a special needs trust, just as an example, would be created for somebody who has a qualified clinical special need, and they are to inherit money, and that special needs trust does a couple things. It allows them to receive the money while not costing them means-tested benefits that they might also be receiving at the time.
Okay.
So depending on the trust's purpose, it determines when the trust should be created and how that plan should work. But for that kind of trust work, there are attorneys who only do that kind of trust work, and I am not one.
Start with Kevin, and then he can refer out should a situation arise and something special needs to be done. But it seems like getting your wills done is important. The first thing to get done. Do you have any stories of special items? How do people classify special items if they want this baseball card collection to go to little Johnny and stuff like that? Does that get put into the will, or do you keep a letter in your drawer and your nightstand and leave me alone?
Yeah, I definitely I like the letter approach. Here's the thing: if right now New Jersey doesn't have an estate tax, the federal estate tax exemption amounts are so high that it only really impacts very few people. But it very well may not remain that way forever. 15 years ago, those taxes did apply more regularly. So it's a concern to name specific personal belongings in the will, because even if it's, a Keith Hernandez rookie card,
Right.
which might be worth $10, if it's named in the will, it may have to be appraised, and it creates a lot of process. I always remember the example of the Barry Bonds home run ball that was caught, record-breaking home run ball. The guy catches it. He just wants to keep the ball. It's a memory. It's one of the coolest memories you'll ever hear of coming out of a baseball game. And the IRS said, well, we need to tax that baseball, and he couldn't afford to keep it. He had to sell it just so he could pay the taxes.
It's out of control.
So it's similar when you name specific pieces of property in a will. You're better off, and for the most part, these pieces of property that most people are bequeathing to their loved ones or other people that they would like to have those things, they don't want to have to deal with needless appraisals for tax ramifications that won't even exist. So the best way to go about doing that is to keep a separate list. You could even store the separate list right with your will. And the separate list and the will itself would say, I might keep a separate list. And if I do, the executor should carry out that list as I wish.
Sounds easy.
Yeah, easy enough. And that's what a lot of people do. And that's what I encourage. These days, I also encourage people with everybody having online accounts, different logins, cryptocurrency accounts, social media accounts. It probably makes a lot of sense to keep a list of login information to those accounts, particularly where we're talking about where your assets are kept. I've heard a lot of people talk about cryptocurrency, and one of the things they like about it is that their spouse doesn't know they have it, And
So
so
you can give that to the lawyer can hold on to it is what it comes down to.
that secret's only good until the grave. After the grave, don't you want her to know about it?
Right.
So, these are things you definitely should think about putting together. You want to leave those that information behind.
I just started creating, a file in a simple Google Doc with password protected that has all of our personal information in it. Should something happen, between my wife or I or one of us passes, that we have the ability and know where our bank accounts are because they're all over the place, unfortunately. There's not one central location for it because we have different joint accounts and different personal accounts, and for now it's great. Upon death, there should be access to some of that stuff, which I think is super important. And then passwords to email, business related materials for me, who's going to take over the business should I suddenly pass away, or shouldn't I suddenly become disabled and something happen? Who's going to run payroll? How is payroll going to get done in my business, right? How's the business going to operate for the first 6 months while it's being sold or taken over by somebody else? So, having these end of life conversations, while difficult, I think are super important. And even the disability stuff, should you become disabled, so there's other documents in the will besides just death related items, right? So what else do we put into our wills?
Yeah. So, there's also custody or who's going to be the guardian of your children. Now, that's a suggestion, right? Couple things about that.
I remember this conversation like it was yesterday.
You're right. And we had this exact conversation at my table.
Right.
The person you name as the guardian of your kids upon your death, it's not compulsory upon that person. They might not want a kid to raise. So you always want to have those conversations with the people in your life who, you think so highly of, that you would like them to finish raising your children in the event of your demise, and that's fine. But the other thing, and they could say no, they could say yes to you while you're living and no thanks afterwards. Situations change. But it's not just that. Anytime there's a dispute over where a child should end up if their parents or guardians were to pass away, the courts have one single standard, and that is what is in the best interest of the child. Mm-hmm. So you may have, an older generation family member and versus a parental generation family member, and you would think kind of the parental generation, that the aunt or the uncle would be the logical choice to take the kid, but maybe they don't live clean, they don't have a good situation, or they live all the way across the country, right, and the kid's in school. And meanwhile, the advanced aged grandparent still lives local, still is clean, still has the ability to look after the child, get the child to school, finish mm-hmm. raising the child, even if it says, the will says, I want my child to be raised by my brother in Seattle. That might not carry the day if it's not in the child's best interest.
Interesting.
Yeah, but it's still good to have a reference to somebody in there, because when all else is equal, the last thing you want is a dispute, right, over it. So
it's good to have those conversations early on. And, we did our wills 5 years ago. I don't know what we put in there as our recommended guideline for care of our children.
Want me to check and let you know?
We might have to look that up and see if that's changed. It probably hasn't, but it's like, one of those things, how often do we need to have that conversation and refresh? So do people come in and update their wills, and when is a good time to, get back in and review, revisit, update? Is it usually an asset situation, a living change, divorce, death?
Yeah, I mean, you just named a bunch of them. Your level of wealth may have changed for better or for worse. Your marital situation may have changed. Your relationship with your members of your family may have changed. Somebody may have entered your life that you want to provide for. Anything that you can think of. But one thing you should always do is pay attention to the news. We're in an era where in response to the pandemic, for example. There's been a lot of spending. It's going to have to be paid for somehow, and I wouldn't be terribly shocked if they, brought the estate tax back to lower levels.
Right.
And if that were to happen, a lot of people who have simple wills might want to consider new wills that contain tax planning vehicles that could reduce estate taxes and other things.
It's all good to know. So many moving parts with it. I mean, the basics is sit down, have a conversation with a good attorney that knows what they're doing, like Kevin, and just start the ball rolling. Start the conversation. Decide whether it makes sense for you personally, for you and your spouse, and for your family, especially if you've made significant financial changes, have a big mortgage, having children, starting a new family. These are great times to do things when you're healthy, wealthy, and wise, right? To get the ball rolling and get your estate and your affairs in order before a situation arises and things can get really, really, really messy. Any other tips, words for the wise that you want to share with me?
Sure.
You have any good story that you want to put out there of?
Yeah, sure. A couple things. I'll take that in order. The basic estate plan consists of a will, a healthcare directive and / living will, and a durable power of attorney. All three of those documents are incredibly important that you have. They're not that expensive to set up and save you or your family members a bundle of money if the situations that they contemplate become operative. Meaning, if you were to become incapacitated, for example, and so you're still alive, so your will doesn't mean anything yet, you're still alive, but you don't have a durable power of attorney set up, meaning that there's nobody who can step into your shoes and do the things that need to be done for you. What would have to happen then is a family member or somebody in your life would have to apply for guardianship. That requires multiple lawyers, multiple doctors, a complaint filed with the court, and a legal proceeding that takes months and many, many thousands of dollars, all because you didn't have a document set up that would have cost a few $100.
Right.
So it really makes a lot of sense to do these things, get it set up. It's peace of mind, and it could really save the day. As far as a really good story, you were talking about the manual that you wanted to leave
Right.
behind, and I was talking about having a list of your accounts and your assets,
Crypto accounts.
yeah,
Your
crypto, but
your wallet
for the more
address.
for the more old fashioned, where do you keep your stock certificates that you hold in certificate form, which takes me back to a client who, I'm working for her estate. I was working for her for many, many, many years. She was an Army librarian throughout the World War II era. She never married. She lived with her brother, who worked on the Manhattan Project, a brilliant military engineer. Neither one of them ever married. They lived in the home where they were raised, and when she was the last to pass away. When she passed away, it was discovered that she hadn't been opening up her mail for a long, long time. So she was living in piles of dividend checks, stock certificates, savings bonds.
Wow.
It came to me in black contractor bags full of unopened envelopes containing one check after the other of hundreds of dollars.
Wow.
Over and over and over from 10 years prior and up to the current. By the time, and we're still seeking out assets of hers to, marshal them and be able to
That all
distribute
goes
them.
to unclaimed property. You got to get it from the state.
A lot of it does, yeah. So between making unclaimed property claims, seeking out through the corporate shareholder services companies what stocks she owns in which companies, and recovering those shares of stock, which she held in actual certificate form, many of which were lost, all the savings bonds that had to be redeemed. We recovered almost $1 million worth of assets that were just laying on the ground in her house.
Unbelievable.
Yeah, it really, really was special. She had left behind 4 nieces that were somewhat, they were all sisters, and they were all somewhat estranged from her for their entire lives. Talk about the long-lost relative that
Right.
passes away. One of them lived in England, and I reached out to her, and I said, you're the next of kin for your aunt, and by the way, it's a lot of money, and so these stories really do
Wow.
happen, and it really was an incredible story. The lady was an incredible lady, but it was amazing to me how she just didn't have any organization of her assets. It's something we're going to continue to have to deal with for a couple more years by the time we are able to find everything. But it's really one of the most exciting
Right.
things that I've ever done is to keep seeing more and more assets and, having the party on the phone with the next of kin to tell them about it.
Things just keep showing up.
Yeah.
That's a good story. That's a good feel good story
Yeah.
to end on. Kevin, thanks so much for joining us today. Kevin Asadi from Zager Fuchs. You want to reach Kevin, you can comment on any of our posts and we'll get you in touch with him. Or what's the best phone number for you?
Oh, our number is 732-747-3700. I have several partners. We all do different things. And anything you need, give us a call.
Good group over there. Thanks, Kevin. I appreciate it. Thank
Thanks
you.
for having me.